Let's get the views of Mr. Offiong, SAN, from our studios in Abuja. Mr. Offiong, what's your interpretation of what's playing out now?
Okay, thank you for having me, Chamberlain. Let me start with a caveat. In the legal profession, we have a rule called the sub judice rule. Basically, it says that when a matter is a matter of judicial proceedings, the determination of that matter should be left to the courts. The determination of that matter should be left to the courts, and that comments outside the courts on matters pending in the courts, touching on the merits of it, are prohibited. So that's the caveat which I want to start with. But my take on it is very simple. You see, part of the problem we have in this situation is the non-recognition of the nature of the government that we have. We have what we call, first, a democratic government, a federal government. Implicit in this are two very clear principles. One is the principle of separation of powers, and the other one is the principle of the autonomy of the different units within the federation. Now, let me speak on the separation of powers. The Constitution clearly recognizes that it is the function that three branches of government at any of the levels of government, except perhaps the local government. At the level of the federal government, you have the National Assembly, the legislature, which has a responsibility for making laws. Then you have the executive, which has a responsibility for executing laws. Then you have the judiciary, which has the responsibility for interpreting the laws. The problem we have right now is a problem where the executive believes that the other branches of government are not performing up to speed, and therefore they should be the only voice to be heard. Now, addressing specifically the situation of the Chief Justice of Nigeria without going into the merits of the case, what needs to be said is this. There is a constitutional provision which allows the courts to interpret and apply the law. The courts have interpreted the laws in certain situations which now apply to what is happening to the Chief Justice of Nigeria. The hierarchy, the executive cannot overrule the decisions of the court. The decisions of the court by the operation of the Constitution is binding upon everybody, including every institution, including the president. As little as the High Court, the pronouncement of the judge of the High Court on a matter affecting the executive is binding on the executive. The executive cannot go against it. Anyone who is not satisfied with what the High Court has determined, his recourse is to go on appeal to the Court of Appeal. The determination of the Court of Appeal supersedes the determination of the High Court. And if anyone is not satisfied with the decision of the Court of Appeal, he can go up to the Supreme Court. The decision of the Supreme Court is final and is binding on everyone. Now, what has happened is this. The Constitution created the Code of Conduct Tribunal. It also created the NJC. It fell upon the judiciary to interpret and delineate the respective areas of function. And the judiciary has done that. The matter went up to the Court of Appeal, and the Court of Appeal determined that in matters involving judicial officers, where you seek to implead them in criminal proceedings in connection with or in relation to matters arising in the context of the office, it must be cleared. So it's like a precondition with the NJC first, before other arms can take action. So the code of conduct is not, so to say, deprived of the overall jurisdiction to deal with matters concerning the breach of code of conduct by public officers. But there's a precondition which it has to meet, and that precondition, when not met, subverts or takes away the jurisdiction of the Code of Conduct Tribunal. I think that's where we are. The decision of the Court of Appeal has not yet been tested at the Supreme Court. So that is the extant decision, the decision which is binding on everyone. And can I say to my very good friend, Mr. Nelson, that part of the problem we have is that everybody thinks that they are judges. And therefore, it is that pronouncement, including a very learned friend, Professor Sergey, thinks that that pronouncement can replace the pronouncement of judges. No, sir. That is not the constitutional position. The pronouncement of judges is what is binding, and it remains extant until overruled by superior court. So, whatever the views of other people are over this issue, there is an extant decision of the Court of Appeal which sets out the due process to be followed in dealing with allegations against public officers or judicial officers. And the Chief Justice of Nigeria is a judicial officer. And that is the issue which needs to be dealt with by, and recognized by the Code of Conduct Tribunal and any other person who is commenting on this. And until that precondition is met, the Chief Justice cannot be arraigned before the Code of Conduct Tribunal. And the proper thing has been done. The lawyers representing him have gone before the Code of Conduct Tribunal to raise the question that that precondition has not been met. And I think that we should allow the Code of Conduct Tribunal and any other court involved in determining that question to determine it, and then we can move forward.
Well, Mr. Fiong, shed some light on this for us, if you will, because, as you know, different schools of thought concerning the interpretation of different judgments as well, including that of Nganjwa versus Federal Republic of Nigeria. Different lawyers believe different things. For instance, there are those who think that they cite Honorable Justice Abimbola Osorigi Obaseki Adejumo's comment in that particular case of Nganjwa versus federal government in 2017, where they say that if a judicial officer commits theft, murder, manslaughter, arson, or crime, they say, look, if these are crimes that are committed outside the scope of the performance of his official functions, he may be arrested and interrogated without recourse to the NJC. Is that the case?
That's the case. But the question here is that the allegation against the Chief Justice is not an allegation that he did something outside of his functions as a judicial officer. It is this, that being a judicial officer, he either failed or falsely made a declaration concerning his assets, an obligation which is imposed upon him by law. So that is a function within his judicial function, which brings it within the case which you just cited.